We are very privileged this morning to have Advocate Peter Volmink joining us. Advocate Volmink is recognized in the law profession. He's an advocate of the Gauteng or the Joburg Bar. He's also an adjunct professor at the University of the Witwatersrand in the Faculty of Law. Also a research fellow at in mercantile law at the Stellenbosch University. So very, very recognized individual, professional. And yeah, Sean also in a lot of our training then refers to Advocate Volmink in terms of our training. So in terms of the topic on discretionary powers. Advocate Volmink is then this morning going to talk to us about discretionary powers, but also in the context of instruction 3 of 2122. I think it was that compliance and transparency instruction. Again, welcome, advocates. Great to have you on board.
Okay, great. Very good to be with you all, and good morning from a rather nippy Gauteng. I hope it's a lot warmer wherever you are. When one talks about discretionary powers, it's useful to think of a donut. And you may wonder, what is the relevance of a donut? But if you think of a ring donut, it obviously has a hole in the center and it is surrounded by the donut. And that is the way the concept of discretionary power has been explained. It is said that discretion, like the hole in a donut. So what this tells us, colleagues, is that if you think about the hole in a donut, discretion is like the hole in a donut. The hole in a donut doesn't exist. It only exists insofar as it is an area that is left open by a surrounding belt of restriction. And discretion in law only makes sense. It is only valid. It is only constitutional if it is surrounded by a belt of restriction. In law, there can't be anything such as unfettered discretion, that one can simply exercise one's discretion in whatever way one wants. Or sometimes it's called vagrant discretion, like a discretionary power that just wanders freely all over the place. That is not the way discretionary power works in law. So think about this illustration of the donuts. No, I'm not selling donuts, so please don't send me any orders. But think next time you see a donut, think about discretionary power and think about how the hole in the donut cannot exist apart from the surrounding belt of restriction. It's a simple illustration, but I think it kind of encapsulates the essence of what I wanted to share with you this morning. Can you move to the next slide? Yeah, perfect. So on this slide, we talk about the different types of power. So before I get into more detail on what discretionary power is all about, let's just talk generally about the way power works in law. So there are different kinds of power in law. You get what is called, well, firstly, there are powers and then there are duties. So an official has the power to make a decision, but the duties imposed upon that official requires that the power be exercised in a particular way. So, for example, you have the power to award a contract. That's your power, no problem with that. but you have a duty to exercise your power in a particular way. For example, by complying with a delegation of authority framework. Someone who exercises a power in contravention of the duty will cause that power to be reviewable in law. So, colleagues, please just keep that in mind. I've discovered that public officials often focus more on the powers that they have and less on the duties that are required to exercise those powers in a particular way. The next category that I have up here is called mandatory versus directory powers. Now, a couple of years ago, maybe 10, 20 years ago, it was a major classification in our law. Our law used to draw a very clear distinction between mandatory powers, and it said if the power is mandatory, if it says you must do things in a certain way, then that requires strict observance. You can't deviate in any way from that requirement. Whereas directory powers, it was said, well, substantial compliance is okay. You don't really need to comply by the letter. I think that rigid distinction between mandatory and directory powers has pretty much been overtaken by what is now called the purposive approach. So there the question simply is whether the power is mandatory or whether it is directory. Has the official satisfied the underlying purpose, even if there's been some non-compliance here and there, even if the compliance is not perfect in every way? Has the underlying purpose of the power been satisfied? So that would be the second category, mandatory powers versus directory powers. Then the third broad category would be express powers versus implied powers. Now, being officials, you would know that you need express powers to justify your actions. There's a principle in our law, and the lawyers in the group will know it well, the principle of legality, that says that an organ of state or an official can exercise no power except those which are vested in that official by the law. But power can also be implied. And implied powers, of course, are not express, but they are a necessary consequence of express powers. In other words, it flows as a matter of logic that because you've got this express power, a certain power would be implied as a result of that. For example, if you have the power to hire an employee, that may be your express power. An implied power would be, well, you also have the power to dismiss the employee, even if it doesn't say that in any piece of legislation, but it is an implied power. It is a necessary consequence of the express power. If you have a power to award a contract, then you have an implied power to terminate on certain recognized grounds. And then perhaps the area that we will come to and dwell some time on is discretionary powers versus rules-based or mechanical powers. Now, I should just say that discretionary powers, as you probably know, they give the officials a choice. They give you a discretion. That is, by the very definition of what discretionary powers are, it gives you a choice. And discretionary powers are typically characterized by the use of the word may, that you may do this or you may do that, as opposed to shall or must. But I will raise a caveat about that with you in a moment. Procurement law in South Africa doesn't like discretionary power. Well, until very recently, when it seems as if the rule makers had a change of heart about it. But for a long time, procurement law viewed discretionary power with a measure of suspicion. And it preferred a rules-based approach. And I will talk about the benefits of rules in a moment. But just to draw a further distinction, discretion helps you to get things done. But rules will help you to prevent abuse. Rules will help you to create more certainty and predictability in the area of supply chain. So when you have discretionary power, things move faster. The end user is happier because you can deliver the goods or services at a quicker pace. There isn't what some officials call the red tape. And you get to your objective quite quickly. Whereas rules, of course, the benefit there is that it does create greater predictability. You don't make up the rules as you go. The rules are predetermined and established. So that's just broadly the different kinds of power that one has. Could we have the next slide? Thanks. So here we just need to spend a few moments talking about the pros and cons of a rules-based system. And the reason why I'm going to have this discussion with you is that some of you may prefer a rules-based system. Some of you may think that it is better to have firm rules in place. Others may be more inclined to say, well, we think we need to give greater discretion to public officials and procurement officials in particular. And I'd like to hear from you how you propose that the balance between rules and discretion can be achieved. But let's just talk about the advantages of having a system that is strongly focused on rules. But the advantages, I think, are fairly obvious, and that is that rules sets out the rights and the duties of officials in advance. So everyone knows what is expected of them. The rules are stipulated. It minimizes the risk of error or, in fact, corruption. And rules will also help the process of reviewing a tender process. So if a tender process gets taken to a judge, because of predetermined rules, a judge would be able to look at the tender award more carefully, and it helps the process of review. If you give wide discretionary powers to public bodies, the tendency in South Africa and universally, it's not a South African phenomenon, it's a universal phenomenon, that wide discretionary powers tend to tempt public officials to give themselves more power than what they have. I have a power to deviate whenever it is impractical to follow a competitive tender process. That's a very wide discretionary power, and we'll come to that. The danger there is that it is tempting. Even if the circumstances don't warrant that deviation, the nature of a discretionary power is that it is beguiling, it is tempting, it calls you to do something perhaps that is outside of what the law would permit. So there are certain advantages to having a rules-based system. My concern with a rules-based system, although I would also want to strike a balance between rules and discretion, but one of the disadvantages of a rules-based system is that the system becomes bogged down in a mechanical and inflexible application of rules and regulations. And related to that, in a strong rules-based system like ours, you often have this phenomenon of minor breaches of the rules being elevated to a level that now affects the validity of the entire tender process. So in a rules-based system, officials seldom draw a distinction between those breaches which are material and those breaches which really don't go to the heart of the tender process. Everything, if you step outside of whatever the rule is, the rule of the tender process, the rules of evaluation, whatever the case may be, those breaches are then seen as showstoppers. They are fatal. And I think in a rules-based system, you often have a fixation with rules and regulations. So officials would spend an inordinate amount of time on the rules and regulations and not look for better ways or smarter ways of achieving their objective. So in a rules-based system, you'd have the main driver of behavior is how can I avoid irregular expenditure? Now, which of course is a good thing. I mean, I think one should be striving to avoid irregular expenditure. But the key driver of behavior becomes an obsession with avoiding punishment. How can I avoid the punitive sanctions that goes with the concept of irregular expenditure? As opposed to how can I extract greater value? How can I be more innovative in my procurement of goods, services, or works? And I think another concern that I have with a rules-based system is that rules become shelters. You know, officials run to that shelter called the rule book to justify a rigid and inflexible, ritualistic adherence to a particular standard. So an official will say, well, I've made the decision because the policy tells me, or the rule book or the SEM procedure document says that. And so there is a tendency to take refuge in those rules and apply them in a way which the law calls fettering. Fettering means to tie one's hands. Rules are used sometimes to tie the hands of officials rather than getting them to apply their mind to the particular facts and circumstances before them. So the difficulty with rules, I think, is that it does create a lopsided emphasis on control and constraint. And I don't think a rules-based system puts enough emphasis on helping officials, empowering officials to exercise those powers wisely, ethically, and efficiently. I think the difficulty is when we have a lopsided emphasis on control and constraint, which I don't think is a bad thing, an inherently bad thing. But if the emphasis is on that and other important aspects like developing the capacity of officials to act in a responsible and efficient manner in exercising their powers, then I think we have difficulty. Okay, can I have the next slide, please? Yes. So the point I make on this slide, colleagues, is that there is nothing wrong with discretionary power. I don't think discretionary power is inherently bad. In fact, I think without discretion, you cannot run a modern state. You cannot run an administrative state without discretion. Discretion applies in a range of areas in the general public administration, and in particular, public procurement. You will know the decision as to when you're going to issue a tender, what to buy, the particular procurement strategy that you are going to embark upon, etc. All of those things involve discretion. But like I indicated earlier, your discretion is never unfettered. even if you are given wide discretion, there needs to be what are called safety rails, guidelines, which helps the official to stay on track. Because if the discretion is wide and there are very few or inadequate safety rails, one is in fact asking for an accident to happen. So discretionary power is not inherently bad, but unguided discretion or poorly guided discretion is at odds with what our Constitution requires. In the slide at the bottom, I refer to the well-known case of Dawood versus Minister of Home Affairs, where it simply said that if broad discretionary powers contain no express constraints, then those who are affected by the exercise of broad discretionary powers will not know what is relevant to the exercise of these powers. If you simply say, go and decide for yourself how you are going to structure whatever the power is that is given to you, you won't know what the decisional reference are. You won't know what the key criteria are that one has to take into account. Can I have the next slide, please? So at the risk of belaboring the point, discretionary power, for it to work well, it has to be well regulated. And for it to be well regulated, the regulations must serve three purposes. It must serve the purposes of confining discretion, i.e., the right amount of discretion or the right degree of discretion must be established. You've got to take into account environmental factors. What is the maturity of the internal control framework of this public body? What is their capacity and their appetite for self-regulation? Because if you grant significant discretion, the fine print, so to speak, or the implied requirement is that the public body must be able to police itself. It must be able to police its own discretionary power. So the first requirement, I think, is to confine discretion, taking into account the degree of maturity of the framework, taking into account what is the general capacity and the appetite of public bodies for self-regulation. The second requirement is, of course, that you must structure discretion. So the manner in which it is to be exercised has to be properly regulated. And of course, one has to then check discretion, make sure that there are adequate controls in place to prevent abuse of discretion. Can I have the next one? There are certain legal grounds to challenge the abuse of discretionary power. So an official who is given wide discretion and who exercises that discretion will or should know that there may be certain legal challenges that goes with the exercise of that discretion. I will come back to this topic when I deal in a moment with impracticality. When is it impractical to deviate from an open bidding process? There's been some case law about that, which I think may be useful to reflect on. But still, just at the general level, discretionary power can be challenged on a number of bases. One of which, of course, would be if you exercise your discretionary power with an ulterior motive. You are exercising your discretionary power, but you have got, it's exercised with a hidden agenda. There is another objective that you are trying to achieve. It may be hidden from public view, but you are exercising this wide discretionary power, not for the purpose for which it is given, but to achieve a different motive for which the law allows. It goes without saying, and flowing from that point, If you exercise your discretionary power in bad faith, in a dishonest or fraudulent way, well, that is a clear-cut case for judicial review. An interesting ground of review is if the official has failed to apply their mind. They have exercised their discretionary power in an arbitrary way or in a capricious manner. And this relates to the issue of rationality or irrationality. So if you exercise your wide discretionary power in a way that is irrational, namely, you took irrelevant factors into account. In awarding the tender, you considered factors that were not even mentioned in the RFP. Or you took factors into account that pertain to hearsay about this bidder's failure to perform in some other division, and that you then use to not to award the bidder without looking into the merits of that claim. That is just an example that comes to mind, where it could be said that you failed to apply your mind to your broad discretionary powers and you took irrelevant factors into account, or you ignored relevant considerations. So improper attention was given to the merits of the bid that was before the scorers. Irrelevant factors were taken into account and relevant factors were ignored. And I think just under the failure to apply the mind, there is also the principle of fettering, which I alluded to earlier. Now, the law does not require you to ignore your internal policies. Internal policies are very important. They need to be adhered to. They are there to guide standardization, uniformity, and predictability in your decision-making. So I don't for one moment suggest that you should not pay adequate heed to your internal policies. But there is a principle in law that if you allow the policy to fetter you, you don't look at the facts or merits of the case before you, and you just say, well, the policy says that we can do X or we can't do Y, that could be grounds for challenge. So let me use a very controversial example. Let's take late tenders. The general rule, and almost an inflexible rule, is that late tenders cannot be entertained. And that is a universal principle and a sound, salutary principle. But there have been cases which have indicated that when the organ of state itself is at fault for the tender, which allowed the tender to be late. Let's say, for example, the bidder has arrived at your gates well before the closing date and time, or before the closing time, only to discover that there is a safety drill and he cannot access the tender box. Well, there are cases that indicate that you can't say, well, sorry, the policy fetters me. The policy does not allow me to consider the merits of your matter. So please don't rush out and accept all late bids. Please don't misunderstand what I'm saying. The golden rule is late bids cannot be accepted, but don't fetter your discretion such that you pay no heed to the merits of a particular instance where there would be a compelling ground. And the only compelling ground that I can think of would be where the organ of state itself is at fault in accepting the late bid. Okay, and then I think the another ground to to challenge the abuse of discretionary power relates to a failure to decide. So under the Promotion of Administrative Justice Act, a decision obviously involves making a decision, but a decision has an interesting definition. It also includes a failure to decide something. So I've sat on this tender for a year. There's been no movement. There is no clear explanation as to why the process cannot be brought to finality. Well, that is a failure to decide. And when you come across examples of an unwillingness or an inability to make a decision or an avoidance of decision-making, then that could trigger a ground of review based on a failure to decide. And it's not just in procurement, in a range of public services. For example, with social grants, there's a whole number of cases where applicants for social grants, old age pensions, child welfare benefits, and so on, have had to wait for years for their application to be decided. And when they went to the judge, he ordered that those applications be processed within a matter of days. So failure to decide, failure to apply the mind, ulterior motive, etc., would all be valid grounds for review. Can we have the next slide, please? And the next one. So you're all very familiar with the instruction note that I just want to spend a few minutes on. I have some concerns with the sudden swing from an environment where we had rigid control. As you all know, Treasury previously exercised very strong control over deviations and variations, and where the pendulum has swung almost to the other extreme of wide discretion. And it seems as if the key principle that runs through the new instruction is that the state or Treasury must give heed to what are referred to as the PFMA functions of the accounting officer and the accounting authority. And although reference isn't made to section 38 and 51 of the PFMA, as you will know, those sections say it is the responsibility of the accounting officer and of the accounting authority in public entities to determine their own procurement policies, etc., etc. So based on that, I think, and possibly being influenced to some extent by the AfriForum decision in the Constitutional Court, organs of state have been given quite significant authority to approve all their variations and all the deviations. And in essence, they have sole authority to decide when it would be regarded as impractical to procure by other means. Can we have the next slide? I think for the sake of time, I'm not going to dwell on this slide. This asks the question, why has there been a change in approach? And I refer to, whoops, I think if we can just linger or just stay on that slide just for a second. What I try to do in this slide, and I'm happy to engage separately with any of you, is that we must differentiate between the PFMA functions of of the accounting officer and the accounting authority versus the role of National Treasury. And as I see it, the fact that the accounting officer and the accounting authority can determine its own internal policies cannot divest National Treasury from setting or exercising what are called framework powers. establish the framework, uniform rules, standards, parameters within which the accounting officer and accounting authority must exercise its powers. It would seem to me that the pendulum has swung completely to placing the emphasis on the role of accounting officers and accounting authorities, and swung completely away from the important role of National Treasury in helping AOs and AAs to structure their discretion, to exercise that discretion in a particular way, so that we don't have unguided discretion. Can we have the next slide? This slide reflects, just for a moment, on whether the instruction is likely to help in the fight against corruption in the country. And I have some concerns here. I mean, as we all know, the State Capture Commission has highlighted the abuse of deviations and variations as one of the key factors. I think in their recommendations, they may have gone too far. They may have, the State Capture Commission says, therefore, there should not be any sole source deviations of any kind. I think that may be impractical, but let's not get detracted by that point. The main thing, though, is that the findings of the Commission have highlighted something that we've always known, and that is deviations and variations can very easily be used to justify departures from the norm. And it isn't always corruption. Sometimes an official may want to deviate from an open bidding process because it may be easier to procure the goods or services in that way. They may want to expand a contract, not because they are corrupt, but because the tender process has stalled and the current contract is coming to an end and now needs to be extended in order to accommodate the need of the public body for goods and services. But whether the motivations are corruption or whether it is just operational necessity, the public, I think, had an expectation that there would be stronger control over deviations and variations. And that is why Treasury is given these framework powers, colleagues. Those powers are meant to help Treasury to strengthen the environment, improve compliance, and reduce abuse. So I think the concern that is simply flagged here is that the way discretionary power has been structured may not be a useful way to strengthen the control environment. I'd like to hear from you practically, of course, whether that misgiving that I have, whether it is justified or whether you find that in the day-to-day application of the rules of variation and deviation, that there is adequate control, there is a discipline, a necessary discipline, not always to choose the easy way because we can deviate or we can expand a contract. Can I have the next slide? I want to actually stop and give you an opportunity to ask questions, but bear with me while I just literally rush through the remaining slides. There's the issue of impracticality, which says that if it is impractical to invite competitive bids, then the AO and the AA may procure by other means, and we know all about limited bidding and all the different kinds of variation by other means. But can we go to the next slide? The concept of impracticality, that you can deviate whenever it is impractical, for you to follow a competitive bidding process? Well, it's quite a vague and open-ended concept. There are very few safety rails in that concept. Treasury tried to introduce safety rails some time ago. I think it said there was a directive of some kind that said in practicality should be understood to mean when there's only a sole source supplier or in the case of an emergency. Well, that isn't an inherent part of the definition of impracticality in this instruction. Impracticality, it just says if it is impractical. Now, it is vague and open-ended, and I think the Constitutional Court looked at this question and said, look, it covers a range of possibilities. It can cover everything from absolute impossibility. So you must say it is absolutely impossible to procure by a competitive tender process, but it can also mean something far less than impossibility. So the Constitutional Court in the case of Rain versus Sasa said to say that it is impractical to procure by other means doesn't mean you must show it was impossible to procure. It may not have been impossible, but the circumstances of your particular transaction may be so, or may be such that an open tender process was not well and sensibly suited for the circumstances. And that is really the kind of fairly open-ended test that the Constitutional Court has created. They say, consider the context that you are dealing with and ask whether a competitive bidding process is well and sensibly suited for the circumstances. There is no predetermined formula. The court wasn't prepared to say impracticality means this or means that, or doesn't mean X or doesn't mean Y. The high-level test it develops is simply, does it make sense to deviate from a competitive bidding process given the circumstances that's before you? Is it well and sensible? Is your deviation well and sensibly suited, or would a competitive bidding process be well and sensibly suited? Look, there are some clear and obvious examples of when a deviation would be justified. Intellectual property rights, maybe one such example, standardization, of trying to avoid a disruption of services by adopting an entirely different product to the one that has been almost institutionalized. Those could be grounds for deviation. Can I have the next slide? But the point that I just want to emphasize here is that although the test is fairly broad and open-ended, is it well and sensibly suited? It is still subject to judicial review. And don't be beguiled by the wide open-ended definition or the wide and open-ended approach to what impracticality means. Because the courts have said in a case called CEO of SASA versus Cash Pay Masters, the case that went all the way to the Supreme Court of Appeal, they said that the mere say-so of an official that something is impractical is not sufficient to justify deviation. So whilst the test is broad and open-ended, it should not mean that your mere, what the law calls your ipse dixit, it simply means your mere say-so. The mere say-so of an official that something is impractical, that is sufficient. The SCA said that the reasons for your deviation must be rational and it must be objectively verifiable and not just based on your subjective view of what the official regarded as impractical. And this is quite an important principle to bear in mind. Pre-Constitution, pre-94, the law said if the law gave officials a very wide field to play in, and it said to officials, if you are entrusted with a discretion, if the law says if you are satisfied that something must be done, if that's the wording of the legislation, then the law can't second guess your decision. You are satisfied. And even if it is a subjective decision, the law will not interfere because you have been granted, those powers have been vested in you. But in the constitutional dispensation, the requirement is that whatever you say are grounds for deviation, it must be rational, it must make sense, and it must be objectively verifiable. Someone must be able to say, it's not just me saying that this is the case. Here are the facts, here are the circumstances. Maybe, can I just see the next slide? Yeah, I think what I'll do is I'll stop there, and maybe what we could then do is to see if you have any comments or questions or contributions. I see Andries Low has his hand up. Hi, Andries.
Good morning, Andries Low here, Eastern Cape Provincial Treasury. Thank you for the presentation. It's really informative, and I really like the way you explained how discretion works. I think an element that tends to also be considered when applying discretion is the difference between being objective or subjective, which probably also takes us down a whole different road of argument, although there's some nice case law around that as well. But what I want to point out, and you specifically ended up making reference to the Treasury regulation that deals with deviation 16A 6.4, that there's two key terms that one see there, and that's the impractical, as you rightly pointed out, and then other means. So what we've done is the Eastern Cape Provincial Treasury already in 2013, 14, 12, 13, I don't remember now. We actually issued a guideline where we defined impractical. And maybe for the sake of not taking too much time, I have shared that guideline with the organizers so that they can distribute it to everybody to just have a look. But something interesting we have sort of dealt with in that guideline was one of the major areas when that deviations regulation is used is when there's emergency. I mean, COVID has been a big one, and it's been abused to the nth degree. And the guidelines that was issued by National Treasury didn't help either. But what we went and did further that maybe need to be understood is in that guideline, we define what we refer to as a true emergency versus an induced emergency. And the reality is we have a lot of emergencies in government, but those emergencies are due to poor planning. And that becomes induced emergencies. And that's actually irregular expenditure. And I believe, and this is the one thing that we as government sort of need to master, we're currently on a drive to avoid irregular expenditure. And I say our planning environment is so imperfect that we can at best deal with managing irregular expenditure. And therefore it's important to deal with, so back to the rules-based scenario, and as treasuries, that's what we do. We make more rules. But the rules are there to actually guide the thinking of the officials and to allow them to identify something as regular or irregular. We do not say necessarily avoid irregular expenditure, because that's a very dangerous territory where people then try to justify the irregular expenditure as something else, and it could simply be a deviation or something like that. But once the AG gets their hands on it, they would just say, hey, sorry, this is irregular expenditure. A good example is where you call something an emergency, you deviate, you appoint a service provider, and then the service provider takes 9 months to execute the work, which doesn't really testify to an emergency. So a lot of things subsequent to the actual transactional decisions also could invalidate the transaction at the end of the day. I just wanted to point that out, but I do encourage colleagues to have a look at that guideline, if the organizers would be so nice to circulate to everybody.
Thanks,
And
Andries. Thanks, Andries.
Thank you.
Yeah.
I interrupted you, Andries.
I was
Thanks very much for that contribution. I will come to Johnson and Ron in a moment. Andries, thank you for sharing that guideline. It would be interesting to look at it. Of course, I'm sure your guideline doesn't limit the concept of impracticality to emergency. I think you gave emergency simply as an example of what impracticality would be.
We actually have 5. There's 5
yes
definitions, and they're quite broad.
Now, the instruction, though, throws the door wide open. It says, if in a specific case it is impractical to invite competitive bids, then you can procure by other means, provided that the reason is recorded and approved. And it says that in this instruction, procurement by other means includes limited bidding, and limited bidding has its own definition, written price quotations, and then procurement in the case of an emergency or urgent cases. So it is not an exclusive concept. It is not limited even to limited bidding, price quotations, and emergency and urgency. It includes those things. So it is a non-exclusive list. It's not a closed list. But guidelines, the reason why I like guidelines is not for it to be applied in a rigid way that fetters your discretion. But officials need to have insight and understanding as to how these broad discretionary powers would be exercised. So I'd be keen to look at that. I saw Johnson, and then we'll come to Ron. Hi, Johnson.
Johnson, can you unmute, please?
Okay, thank you, sir. I would just like to ask about the discretionary power that is vested with the bid evaluation committee. I would give an example. Let's say maybe you have listed a requirement that is more of administrative. You have indicated that the bidder must tick to indicate that they comply, and then also cross-reference the evidence. But then maybe the bidder does not do that, but they provide, let's say you have requested for reference letters. All those reference letters, they are there, but you have indicated also, maybe beneath the table, that if you fail to tick comply or fail to cross-reference, you will not be considered, the bidder will be disqualified. So if you look at it, you can see that it's more of an administration, but I want to understand the extent of the clause that indicates that if you fail to tick, you'll be disqualified. How is it binding maybe in the court of law? Thank you.
Yes, thanks for that. I can give you a very long answer and I can give you a very short answer. So I think given time, I will try to give the short answer, simply because, you know, there isn't a predetermined clear-cut case how to answer it. But the short answer that I will give is to refer you to a decision called Transcreations versus, now the public entity is slipped now. Anyway, if you like, I can give you the exact citation offline. But in that particular instance, bidders were told to tick their compliance or on a certain form pertaining to certain technical requirements. So you had to tick, yes, I can comply, or no, I can't comply. And that would then be regarded as a responsive bid. As I recall the facts, bidder A didn't complete that form at all and was disqualified. Bidder B didn't tick, but he wrote, I'm able to perform, or I'm able to comply. And his bid was accepted. Bidder A, when he found out that he was rejected, but bidder B, who also didn't comply by the letter of that returnable schedule, rushed off to court and said, Judge, this is unfair treatment. We both should have been disqualified. Whether I didn't complete or whether, and this one just didn't tick, we are both equally non-compliant. And the court disagreed. The court said that the purpose of this document, whether you tick or you don't tick, the purpose of the document is to signal to the organ of state that you are capable of performing against the set standards stipulated. Now, if you don't complete the form at all, you are not fulfilling the purpose of that document. How is the organ of state supposed to know that you can comply or that you can't comply? So your exclusion is justified. But the other bidder met the underlying purpose, and applying a purposive approach, the judge said, well, the failure to tick is not material. What is material is what appears in this particular document. Mm-hmm. So that's just a view that I have off the top of my head. Just give me one moment. I'm being pressed. Oh, okay, that call went away. Oh, I'll have to wrap up now, but I did promise Ron that I was going to take his question. Ron, I do see your hand.
Peter, incredibly fast. Your outstanding PhD, I would recommend people read. Your article, I read during your session now, it's excellent. But we would disagree on the direction, because we're in the innovation space, we procure research infrastructure, and for us, National Treasury completely went overboard previously. I think they corrected it. We welcome the fact that they have given this degree of discretion. Thirdly, you've framed the discussion around rules versus discretion. I believe that for example, in accounting, when you compare the two paradigms, it's rules versus principles. And as such, I would respectfully disagree that there are no parameters per your article. There are parameters, there are principles as per the Constitution. And as such, you have those, and you have precedent within the USA with the other transaction authority, where they adopt a principles-based approach. The last 2 points. One is that the public protector has laid down, I think, 3 different principles which are worth consulting for urgency and emergency. And fifthly, it's a question, and I'm not sure you'll have time to answer it, but maybe we can do it offline. If you're saying that the purpose of approach is now the leading approach, what does one do when the purpose is not clear? As your article is made clear in in the latest instruction note. Is there still room for a substance over form argument? Thanks, Peter.
Well, thank you, Ron, for your difficult question at the end there, because that is it's a tricky one. You know, a purpose, one would like to think that the purpose of a document is self-evident. All you have to do is to open the document and the purpose will leap out at you. Well, anyone who has read an RFP will tell you that it isn't always clear why a particular provision has been inserted. I sometimes speak to officials dealing with tenders when a bidder was excluded for failing to attend a compulsory tender briefing session. And I ask them, but what was the purpose of having this in this tender document? And I can tell you there are times when the official says, look, it's always been there. It's part of the precedent. So that is why it has been included. So the purpose isn't always self-evident. And that is one of the shortcomings, of course, of the purposive approach. But coming back to your earlier point, I don't think that my argument would be that there are no guidelines in this instruction, and that it is all airy-fairy and you must make up your own rules. I mean, if one looks at the document, there are certain very broad guidelines. My concern is that, you know, given our environment of chronic abuse of variation and deviation, to swing from a state of considerable control and to then vest wide discretion in public officials within a climate of chronic abuse, I think is a possible ground for concern. I'm glad to hear that it works well in the area of innovation, and that's exactly what institutions like yours would be grappling with. And I'm pleased to hear that it works well. Perhaps offline or in a separate session, I'd like to have an understanding, though, of how do the controls work? How do you decide that? When do you rule against yourself? Is there a sufficient level of internal control where you say, no, there may be a strong motivation, but the decision maker within the organization says, this is a bridge too far, we will not allow it, and what are then the factors that are taken into account? But I think that for the sake of time, we may need to have a separate discussion about that. Andries, I see your hand is up again. Can we take you as the last contributor?
Yes, sorry, I just want to give a bit of practical advice. You just mentioned the whole issue of the form being filled and the form not being filled. And again, I sit in a committee that looks at all the high-value tenders in the province, and we grapple with that all the time because we sometimes believe that the rules-based approach sometimes makes bids uncompetitive because you eliminate everybody but some expensive oak. And that's also not in our best favor. So we came up with a concept, and it's basically based on the interpretation of the Rainbow Civils judgment, where we started talking about material and non-material deficiencies in bid documents, and that committees must actually consider tolerating. So here's another form of discretion. Committees must consider tolerating certain non-material deficiencies in bids to allow the bid to be more competitive so we can have more players on the field. But we say we're not relaxing rules. So how can you be tolerant and not relax a rule? It's very simple. If the guy who you tolerated does end up becoming a winning bidder, nothing prevents you from still imposing all the rules on him at that point in time by making sure he's signed all the documents, filled in all the forms, and dotted all the I's and crossed the T's. Thank you.
Interesting. So in other words, you accommodate the non-compliance to a degree. If it is non-material, I think you said, and
Yes.
in a separate discussion, I'd like to understand.
And
whether you
our
follow-
definition of material is very simple. As long as it does not influence my evaluation. So as long as it's not the price or not the factors associated with the functional evaluation, it could be, then it is just information, that, like identifying the supplier, basically. It's filling in your SBDs and those kind of things. You don't use those things in your evaluation.
I must tell you, Andres, that makes sense to me. And also, I think CIDB in their standards for uniformity, when they deal with what a responsive tender is, they also have guidelines as to what a material deviation is and what it is not. Just be mindful, though, that our law is still quite conservative, despite the purposive approach that I have been going on about, that the Constitutional Court has heralded. There is still a line of cases, particularly coming out of the SEA, where they say that we're not going to dictate to an organ of state what its rules are. But when it incorporates a requirement as a mandatory requirement, it has no power to deviate from that or to condone non-compliance unless they are given that power in the regulatory framework or in the bid document itself. Unless the bid document gives you a power to condone non-compliance with a mandatory requirement, says cases like Dr. J.S. Maroka and Bertram Municipality and the Pepper Valley.
Yeah, I actually studied that case as well.
Yeah,
Yes.
so you will know that there is just that little red flag that could go up. But I must tell you, I support not a lenient approach, but I'll just call it the purposive approach, where you don't simply look at every instance of non-deviation, but you raise questions of materiality and issues of purpose.
So sorry, just one last comment on that one. So the term we use is we, and it actually sidesteps the whole Maroka issue. We do not, as I say, we don't relax the rule. We just move the enforcement of the rule to an award stage as opposed to an evaluation stage.
At the tail end, yes.
Yes. Okay, thank you. Sorry, time's up.
Thank you for that. I've had my phone has been shouting at me a little bit, so I'm afraid I need to step out of this very interesting conversation that I am enjoying. But colleagues, do feel free to engage with me. I wrote an article, in fact, it's on the screen there, a short while ago on this topic, and you can have a look at that, and if you wish, you can engage with me one-on-one at any point that you wish to. Thank you, Henry.
Thank you, Peter. So really, thank you very much. I see as we already, what you agreed is 25 minutes over what you've agreed to initially. So we are really thankful to you, and we must certainly get you back. I think there's a lot of discussion more on this, and so we will certainly try and get you back at some other time. But for me, it was very insightful. So thank you very much.
Thank you, and all the best.
Thank you. Cheers.